introduction. And it's a pleasure to be here, and I thank very much Professor Emanuele Arezzo for calling me to this session of corporate law, which has taken the first place, even if it was supposed to be in the last place. But with my colleagues, I hope that it will be an interesting introduction for you all, and then developing all the issues that are more concerned with AI, which are probably those connected with intellectual property and all the other issues. Okay. We can now start. I will try to be very, very brief, because the issue that I have chosen, that has been chosen for our discussion, is in reality wide and needs to be compressed to be understood in some minutes. The issue is digital shares and the blockchain, and I added in Italy because in the world it has many implications that we cannot manage. In each and every country, in each and every environment, there are different positions as to whether digital shares and the blockchain are permitted. In Europe, we have a framework. The basic framework is that of the so-called pilot regime, DLT pilot regime, which was introduced in the European Union as of 23rd of March of 2023, which provides the legal framework for some crypto assets in particular. These are the crypto assets which also qualify as financial instruments under the other directive, which is regulating our financial markets, so the MiFID II. And it introduces some concepts that are useful for our discussion, which most of all are DLT, multilateral trading facility. This is a platform. We will discuss about a platform facilitating transfer of shares in a particular environment, which is the digitalized environment. And then we have a complementary service provider, which is the settlement system, which is also defined by the regulation, which is, in our view, the most important part of the regulation. We deal with settlement in particular more than trading of shares. And then, of course, there is the possibility to have a platform which combines the two activities of facilitating trading and making settlement possible. This regulation defines, first of all, what is a transferable security. Transferable security means a security which is transferable, because otherwise it's not a security, that are issued, recorded, transferred, and stored using DLT. It should be useless to point out what is DLT here, but just for helping the discussion, it's distributed ledger technology. So it's a technology using distributed ledger. We will discuss about the use of distributed ledger in corporate law, and in particular in the circulation of shares. To have these platforms and operators at work, we have first to change the issue that is transferred or stored, which is the share. So far, shares are thought basically as paper shares. So the idea first, before having a blockchain permitting the transfer of shares through this technology, was to have tokenized shares. Was it possible before the DLT pilot regime? This is, we can go to the next slide. This was exactly a research paper that CONSOB promoted in 2023, just to point out that the number of the paper is the same of the number of the law. So it's not confusing. It's a bit confusing, but it's correct. I co-edited. I helped CONSOB issue this research paper, and the research paper pointed out what the main points were before any legislation on this point. So what was the state of art just before issuing a legislation? First of all, we have to point out that listed companies must comply with another piece of European legislation, which is the central security Securities Depository Regulation, the CSD regulation of 2014, which requires, as the name explains, centralization. We are discussing decentralization. So it's a bit difficult to have these two pieces of European legislation to dialogue together without overlapping. It will require more efforts from the European Commission and from the European institution to be coordinated. But since it's a pilot regime to be introduced, all the member states, more or less, have studied, have questioned themselves whether or not it was possible for other companies than the listed one to have digitalized shares, either in the form of paper shares being tokenized or non-paper shares being issued as digital shares as native technology. I go to the results of this research paper. This research paper says there is no possibility to take advantage of the issue of paper shares and then of the tokenization of those paper shares. Better to focus on the possibility that companies being set in Italy have to issue paperless shares. This system gives a very important role to a book or a ledger, which is the shareholders' book. In our civil code, there is a rule which was issued many years ago, which allows businessmen and companies to hold their records, to hold their books, all their books with electronic means, without giving any description or without giving any limitation to the use of which technology it refers to. So the conclusion is that it was possible also before any legislation to have the shareholders' book of any società per azioni, so of any company in this form, to be digitalized, and not only digitalized, but use the DLT technology. In this case, the shares which would be represented by records in this shareholders' book could be understood as notes, could be understood as positions in a DLT, so in a distributed ledger book. Was it possible? Did we have any limitation coming from the existing legislation? Not really, because it is true that some of the rules applying to paper shares are applying also to paperless shares. In particular, those rules requiring to check whether or not the seller is capable of disposing its shares, or whether or not the seller and the recipient, so the acquirer, have signed in a due form a contract. But it is possible, since there are no public interest issues at risk, to change these rules into private rules, which make the system substitute the legal rules. So the conclusion at that time, it is the beginning of 2023, was that issuing shares in Italy using the DLT technology was possible, but only limited to paperless shares of società per azioni. It was not possible for SRL shares, which are probably the type most used in our business practice and which were most interested in the possibility to issue shares as digital shares, because there is a regulation which has anti-money laundering purposes, which focuses on anti-money laundering purposes, which requires that each and every share transfer is controlled by a public officer, which is generally the notary, in some cases also other professionals. So in which sense this new legislation amends and helps this process of digitalizing shares develop? First of all, it defines which digital instruments, which financial instruments may be digitalized. It makes a list which includes both shares and bonds of a società per azioni, as referred, for that reason probably, only bonds of a società a responsabilità limitata. It gives possibility to Consob to issue a regulation which includes also shares of an SRL into the list of the financial instruments that may be digitalized, and providing the rules that should be applied not to strike against the anti-money laundering reasons that are behind the legislation on SRL shares. But the Consob has not yet issued that regulation, and probably it will not issue such a regulation because a later law, Legge Capitali, introduced for SRL shares the possibility to take advantage of the dematerialized system, which is really costly for SRL, but it's a possibility which does not strike with anti-money laundering purposes, and maybe this will suggest Consob not to permit digital shares also for SRL. Then the other two categories of financial instruments which may be digitalized is the money market instruments and the shares of investment funds, which maybe will find this opportunity interesting. This issuing of digital shares is based on the concept of distributed ledger technology. It is an information repository that keeps records of transactions, so it supposes that shares are transferred with the system and inside the system, and that they share across DLT nodes, as we know what they are, using a consensus mechanism. This is exactly the definition that the pilot regime gives and which the laws entirely, fully shares. Other important principles expressed in the main part of this new legislation is that issuance and circulation of digital financial instruments are performed by a distributed ledger holder, which is, as we have seen, those figures which already the DLT pilot regime sets out, such as an SS DLT or a TSS DLT, but it adds that holder may be also the issuer. The shareholders' book, which may be treated and considered as a distributed ledger, is the ledger in which shares circulate and which is held by the issuer. This is an important step towards the possibility to have such digital shares. Maybe it is the result that we have reached also in absence of the law. So what does the law add to the results that we already had thought it would be possible to do without any legislation? First of all, it says, replicating the rules of other laws which are applicable to other shares, dematerialized shares in particular, that the shareholders' rights, so the reason why someone holds shares depends on the registration. So the right to vote, the right to take part to the shareholders' meeting is granted to the holder of the registration, provided that there is a registration which links shares to someone. First rule, innovative rule, which the law has decided to set out is that to determine who is the person who may vote and take part to the shareholders' meeting, issuer should define a so-called record date. Record date is a date before the shareholders' meeting in which the registration is relevant, so that after that date, shares may be traded without changing the list of participants to the shareholder meeting. This is okay in principle. This is a rule that we have already at work for dematerialized shares, so for listed company. One may ask itself whether or not it was necessary to have a record date at work in a system in which the holder of the ledger is the same issuer which must acknowledge the legitimacy and the capacity of each and every shareholder to take part to the shareholders' meeting. We have to recall that in a dematerialized system, the issuer doesn't know who shareholders are at the very moment of the shareholder meeting, because the system is intermediated by the intermediaries, the depository, the system which takes account of the information that intermediaries give before the shareholders meeting to the issuer. So maybe the issuer deciding to issue digital shares may decide not to take advantage of a very old record date. They may make the record date be put on the same day of the shareholders meeting. That would help perhaps shareholders not to fear that something happens in between the date of the list and the date of the meeting. There is a little risk for shareholders using this system, because it is the issuer forming the list of legitimated people, participants, to the general meeting. But in the same time, the law requires that every participant to the system may access in every moment the system to extract, download, print if it wants, the record which says that he is legitimated to take part to the shareholders meeting. What happens if those two information differ one to another? For example, the print of the shareholder is taken at 10 o'clock in the very same day when the issuer takes his record date list, but the operation is performed afterwards. This is a problem which is solved by itself in the system of dematerialized shares, and which will require a solution in this different system. Also, dividend payment, which is generally thought to be the system, which is thought to be the situation in which the issuer has declared and decided to distribute dividends, and then it pays the dividends, generally everyone thanks to the people who are shareholders at the time of payment. No, in the digital system you have to set a record date too for the dividend payment, so that the payment is done to the one who was shareholder at the time of declaration. Do we really need this rule, which is different from the general one? We don't know exactly, but it's a choice we have to consider. And in the end, there is the replication of a general rule which was introduced in our system for dematerialized shares, and which is an interesting reproduction of typically security law rules into these dematerialized or digital environment. It says the issuer may not object to shareholders other than objections which are personal to the shareholder, for example, non-performing the obligation to make a contribution. So you are suspended as shareholder. This is clearly possible to object. And general to all shareholders. This is an interesting notion which has been studied throughout times, and it is not clear whether or not it just says the company is a living entity. It changes its statutes and its rules, so changing of the statutes on the rule are objectable to each and every shareholder, or whether it is possible to object to shareholders some other things, for example, over issuing of shares. These are doubts that are generally addressed also for dematerialized shares. But as I said before, the most interesting point is that you don't really need to have a DLT performing a shareholder's book unless you want to facilitate share transfer. Share transfer, of course, even if the company has chosen to have digital shares, is based on consensus, which is in English environment known as signing. So the contract which makes the obligation of the seller to sell or the buyer to buy. But then it needs to be to have some formalities afterwards to make it effective against third parties, against the issuer. This is done through the system. And maybe having such a system is not something which makes it easier, but more difficult. For example, rules on paper shares are not applicable to digitalized shares, so as paperless shares or dematerialized shares. So basically, we don't need any notary to sign the contract. We do not need the notary to perform the contract, so to close the contract or to settle the contract. In the other environment, in the paper environment, we need the notary at least for the girata, so for the act in which, by which the acquirer is entitled to show as shareholder towards the company. Intermediaries are not present, like contrary to the system of the dematerialized shares, so they cannot help this transfer of chain happen. I was discussing yesterday, just imagine if a company choosing the digitalized shares has only one shareholder. So only one node and one position, and the only shareholder wants to sell part of his shares to someone else, which is not already shareholders. The system is complicated because you have to ask the issuer first to open another node, to create the technology necessary for the transfer of the shares, and then perform the transfer of the shares, which requires, as every transfer in a DLT system, an input from the one having the key and the validation of the operation. Is it easier than giving someone a paper share? No, it is not easier. So the idea is that DLT is designed for companies really using the market. But for listed company, it is not yet available. So it's a transition system which maybe we will appreciate in the future, but which will probably not be used in a close time because it's costly and because it doesn't help, really. And also, there are two important issues to consider. First of all, as in the Bitcoin area, it's already acknowledged. It is really complicated to know what happens if someone holds a Bitcoin and dies and he doesn't leave the key in his testament, in his final will, in his wills. What happens if this happens also for company shares? May the issuer overcome the system that it has created and just transfer the share to the heirs? This has a regulation for paper shares and for paperless shares. This has no regulation for digital shares. Second point, which is perhaps more important under an economic point of view, what happens if a creditor wants to seize the shares? May he only go to the issuer and say, I want to seize the shares, block the shares. And the issuer says, but I have no ability to block the shares. You have to go to the shareholder because he's the only one who may dispose of the shares. This problem is really similar in a dematerialized system, but in the dematerialized system, you can go to the intermediary and block the shares. So this is a situation that someone has to face. It's a very, very comfortable system not to have creditors behind you, haunting you. The law replicates another rule, which is really traditional for securities law and for dematerialized shares as well, which says the recipient of a registration has protection, notwithstanding that maybe the seller was not the real owner of the shares. But we all know that losing a piece of paper is possible and finding a piece of paper is possible. Finding a digital shares on the ground. It's not imaginable. So we have to think a different situation in which this rule could theoretically apply. The only situation that I have imagined is this situation, and maybe the rule is significant. A transfer acquires a share from B, and B has acquired at its turn the share from C. But the transfer between B and C is invalid for some reason. It was unknown before A acquired the shares. Under a common principle system, C may go to A and say, these are my shares. I want them back. If we have this rule, which is taken from the circulation of touchable things, the protection of the possession in good faith, then the third party is protected. But the question that we have to put ourselves is, do we really need to protect the recipient in an environment using DLT, or should we think about protection of those having registration and maybe losing registration for some reason, for a break of the system? I think the legislator has made an easy task replicating all the rules which have been thought over time for shares, for paper shares and for paperless shares, but maybe he should ask himself whether or not these rules are really useful to solve the situation that this environment may arise. Concluding remarks. Maybe I have already anticipated my point. I don't think that this legislation helps very much the development of digital shares, because we reached the conclusion before the law that it was possible to have digital shares. Maybe it's interesting for practice. Maybe it's not interesting for practice. There's no limitation from the system. This regulation confirms that it's possible, but in my opinion, adds no legislative facilitation for choosing the system instead of the others. The first step to be made probably is to do something at European level so that the CSD regulation and the DLT regimes are paired, are in some way harmonized one another. So when it will be possible to have settlement systems performed on DLT also at the EU level, maybe this law will be very useful and very interesting. Thank you for the attention.